Hello everyone, I'm George from Ireland, so welcome back to my English law channel. I'm carrying on looking at tort, and this time looking at trespass to the person. So trespass is generally going onto somebody's land, which is a civil wrong, but here we're talking about touching someone in an unjustifiable manner. So we all know from criminal that battery is inflicting unlawful force on someone else's body. But trespass is also a violation of bodily integrity. I hope violation doesn't come across as too strong there. So a battery is to uphold a person's dignity. So this is where someone's rights have been infringed, even though there's been no injury, no bruising, no cutting, anything like that. Taking someone's fingerprints when you shouldn't, or grabbing someone's arm when you should not do so, things like that. Now, there are a number of valid defences to these. So the claimant has to show that his or her physical integrity was interfered with, and then they could be compensated under tort. We know that battery is the criminal offence, trespass is the tort civil wrong. So this trespass of the person, it must be deliberate and it must be direct. So there are a number of cases about this. Now the court has interpreted this directness and this deliberateness with a certain latitude. Scott against Shepherd 1773 is a leading case here, where a man had a lighted firework, he threw it into a marketplace, and so one person got it, hadn't gone off yet, and he threw it on, and it became like a case of like a game of hot potato. So several people threw it on, and eventually, of course, it exploded, causing an injury to the plaintiff. These days we say the claimant. So the injury wasn't a direct result of the person throwing the firework in, because there was you could argue novus actus interveniens. Several more people had passed it on. Perhaps an action should be brought in case. Case is what they used to call negligence. But the court said, no, we can stretch the definition of direct injury, because that was more or less automatism from the other people having to throw the firework on because they didn't want to hit them. The defendant's act of throwing the firework had not broken the chain of causation, because it was an instinctive reaction of the others to try and get rid of it. Haystead against Chief Constable of Derbyshire 2000 is an important case here. So someone was committing battery on a woman who was holding a baby. So she dropped her child because she'd been attacked, and the infant sustained an injury. So the defendant had committed battery against the baby, even though he'd not actually touched the baby. So the physical force had been directly applied to the mother, but the intervening actions were seen not to vitiate the culpability, the liability of the tortfeasor. So remember, the defendant's action must be willful, like Nash against Sheen, 1953. In this case, the defendant was a hairdresser, was held to be liable in battery because the tone rinse that was applied caused a rash, and the plaintiff had asked for something else, which is a permanent wave, which wouldn't have caused a rash. So the hairdresser's action in applying the rinse was purposeful, even if she didn't actually want to cause a rash. She hadn't done what she was told to do. She'd applied the wrong thing, therefore against the person's will in a sense. So we'll look at also Wilson and Pringle in 1987. Here there were two schoolboys, and they were engaging in some rough play, and one boy pulled on another school bag from his shoulder, and that caused the boy to fall and hurt his hip. So what was the judgment? Well, the defendant admitted he'd been engaged in horseplay. So this was a case of battery, there's no defence. But the Court of Appeal then overturned the earlier finding in favour of the claimant, and said we must have some hostility. There was no hostility in this horseplay, volenti non fit inuria. The other boy was willingly engaging in some rough play, and you accept that you'll be slightly hurt during that, or else don't do it. So the court said, unless it's self-evident from the act itself, the plaintiff must show the contact to be hostile, close quotation. Otherwise, he wouldn't be allowed to play sports. There are contact sports. You bump into each other, you bruise each other, and if you don't accept that you're going to get a little bit hurt, don't play those sports. the hostility element doesn't require ill will or malevolence, so the court held, but nonetheless there was no hostility in this case. The two had willingly engaged in play of this kind. So the situation's unclear. There was a medical negligence case called Ray F. in 1990, and Lord Gough sat on this one. He said that a battery is any intentional physical contact which is not generally acceptable in the ordinary contact of life. So shaking someone's hand, you put out your hand to shake theirs, they don't want to. If you happen to touch their hand, they withdraw it. Okay, that would not be a battery. Tapping on someone on the shoulder to get their attention, that's not battery. When you're on a crowded tube train and you move and your shoulders are going to brush others, that's not battery. So Collins and Wilcock was an important case here. So the touching must involve a level of hostility. So a crucial issue was raised by Fagan against Metropolitan Police Commissioner in 1969. So here the defendant was driving his car. He stopped his car and the tyre happened to be on a policeman's foot. So no battery being committed, it wasn't a hostile act. And the policeman said, "Get your car off my foot," and the defendant refused to do it. Well then, that became a tort. That was a hostile act. So transferred intention is a question which came up in Livingston against Minister of Defence in 1984. So there was someone who was a soldier serving in Northern Ireland at the height of the conflict, and he was firing a baton round. That's a big round. It's like about the size of that pen, but it's flat on the end. It almost never kills people. So it'll hit them, it'll hurt them, cause a big bruise. So it was meant to be a less than lethal weapon. With riot situations, the other lot are throwing stones, so we're not going to raise the level of hostility by firing live rounds. We'll fire baton rounds. But he fired his baton round, and that was deliberate. But then he missed the rioter he wanted to hit and actually hit somebody else. The soldier was held to be liable in battery because he'd struck someone who he wasn't intending to hit. So how much force has to be used? Well, in Collins and Wilcock, 1984, here was a policewoman. She was questioning a woman she suspected of being soliciting for prostitution. Remember, prostitution is not and never has been illegal in England. It's illegal in Northern Ireland, for example. But in England, there are offences around it, such as trying to promote yourself, standing on the street saying, "Hey, do you want any business? Are you looking for a good time?" Promoting your prostitution services, carding, those tart cards and phone box. I'm not sure about the internet ads, maybe, but they always call it massage or escort, but everyone knows what that means. So this police officer took hold of the suspect's arm to detain her and caution the woman. The woman scratched the police officer's arm. So there was an appeal because the suspect had been convicted for assaulting the police officer by scratching her with her long nails. Especially if you assault a police officer while she's discharging a duty. But it's found that police officer had gone beyond what she's supposed to do and was not exercising her powers of arrest. What the officer done in touching the person's arm was a battery. So bear in mind, there's a difference between restraint in the situation and touching someone's to attract their attention, touching their arm or something. And that would be permissible conduct in social life, as Lord Justice Gough said in Ray F. Toodaloo.